Speakers of this panel will provide factual account of the NSL and share insights on the application and interpretation of the NSL, hence strengthening the international community's understanding and confidence in Hong Kong's legal system and business environment.
May we now invite the moderator for this session, Mr. Amirali NASIR, MH, JP, Vice President and Chairman of the Constitutional Affairs and Human Rights Committee of the Law Society of Hong Kong.
Thank you very much. Good afternoon, everyone. This is a very exciting session. So, as a preamble, I've been traveling for the Law Society all over the world and facing same questions again and again. How does the NSL work in Hong Kong? What's Hong Kong like? Is it Hong Kong the same? Is there courts, are the courts independent? Is there religious freedom, etc.? What is NSL? When does it apply? And others questions like, I want to continue to do business in Hong Kong and in China after COVID. Will NSL affect my business, my investment, my personal life, my ability to go for prayers in a church, temple, or masjid? So the Law Society has put together a distinguished panel of speakers to answer some of these questions that I have faced. And our distinguished panel have given up their precious time to both help the Law Society and those who are interested about this area. So first of all, we have Professor Albert Cheng, DBS, SBS, JP, Professor and Chair of Constitutional Law, Department of Law, University of Hong Kong. We also have the Honorable Horace Kwok-kwan, SBS, JP, Deputy Secretary for Justice, the Government of the Hong Kong Special Administrative Region. We will then have Mr. Grenville CROSS, GBS, SC, Vice Chairman Senate of the International Association of Prosecutors and former Director of Public Prosecutions of the Department of Justice, the Government of the Hong Kong Special Administrative Region. We also have the Honorable Tang Peng Keung, GBS, PDSM, JP, Secretary for Security, the Government of Hong Kong Special Administrative Region. And we also have the Court of Final Appeal Chair there, because Mr. Stephen Hong is presently in the Court of Final Appeal, so I call that the Court of Final Appeal Chair, which is ultimately our Court of Final Appeal in Hong Kong. So with that, I'd like to invite Professor Albert Chen to please open this session with a general introduction. National Secretary Chen.
Sorry, I'm not able, oh yes. So thank you, Chairman. Good afternoon, ladies and gentlemen. As the first speaker of this session, I'm going to give you a general introduction to what we call the NSL, the Hong Kong SAR National Security Law. As we all know, the origins of the NSL can be traced back to one particular provision in the Hong Kong Basic Law, the constitutional instrument of the Hong Kong SAR. There is in the Basic Law one article, which we call Article 23, which actually both authorizes and requires the Hong Kong SAR to enact its own national security legislation. The word national security is not mentioned in this provision, but actually this provision deals with matters of national security such as treason, sedition, subversion, secession, etc. So the reason why we had this provision in the Basic Law is that because of one country, two systems, the national security law of mainland will not be directly applied to the Hong Kong SAR. So Hong Kong will introduce its own national security law. As we know, we in Hong Kong continue to practice the common law system. Over 90% of Hong Kong's laws continue to be the existing laws at the time of the handover. Very few mainland Chinese laws are applicable to Hong Kong, including, for example, the Chinese nationality law, or laws relating to foreign relations and other matters outside Hong Kong's autonomy, such as defense. So in the year 2003, the chief executive, Mr. Tung Chee-hwa, introduced a bill for the implementation of Article 23. This is a national security bill introduced in the legislature, the Hong Kong Legislative Council, in early 2003. But because of strong public opposition led by the so-called opposition political parties and politicians, there was a very big demonstration of an estimated 500,000 people on the 1st of July 2003, as a result of which the government decided to shelve the bill. So there was no legislation implementing what we call Article 23 of the Basic Law. Even though the subsequent chief executives took office and had opportunities to reintroduce the bill, but they actually did not decide to do so. Chief Executive Donald Cheng, who succeeded Mr. Tung Chee-hwa, set as his priority the introduction of universal suffrage. He persuaded the central government to introduce a timetable for the introduction of universal suffrage. So the issue of national security legislation was postponed. After Mr. C.Y. Leung succeeded Mr. Donald Cheng as chief executive in 2012, Hong Kong experienced a period of political instability with a movement against the national education curriculum in schools, followed by the so-called Occupy Central movement. So there was no opportunity to deal with matters of national security at that time. Then in 2017, Mrs. Carrie Lam succeeded Mr. C.Y. Leung as chief executive. Her priorities as she took office were on matters of economic development and improving people's livelihood. So she did not mention the task of legislating Article 23 at the time she took office. But soon after she took office, there was an incident, the so-called Chen Tong-kai incident. A 20-year-old Hong Kong man traveled with his girlfriend to Taiwan, and he had a quarrel with a girlfriend and murdered her there. And he then returned to Hong Kong. The Taiwan authorities requested the extradition of Chen Tong-kai to Taiwan. But it was pointed out by legal experts that Hong Kong law did not actually provide any legal basis for such extradition. At that time, even though Hong Kong has extradition treaties with more than 30 other countries, there was no legal basis for extradition as between Hong Kong and any part of China, which according to Hong Kong law includes Taiwan, Macau, as well as mainland China. So in order to deal with the matter of Chen Tong-kai's extradition, the government under Mrs. Carrie Lam introduced a bill, an extradition bill, which again became controversial as, or even more controversial than the Article 23 bill in 2003. Although Mrs. Carrie Lam decided to shelve this bill after big demonstrations, almost escalating into a riot in the middle of June. Although she decided to shelve the bill, the movement against the bill continued and escalated into riots of even greater scale. In fact, riots which Hong Kong had never seen since 1967. Those of you who were in Hong Kong or you were abroad but watched news about Hong Kong would know about the severity of the violence and riots at that time, which continued for many months. Even though the bill was shelved in the middle of June, these riots continued into October and November, and in fact, in November, they escalated into a greater degree of violence than ever before. So the central government considered this situation carefully and decided that there was actually a loophole in Hong Kong's law regarding the protection of national security. Hong Kong SAR had not fulfilled its constitutional duty of legislating to implement Article 23 of the Basic Law. Now, Hong Kong, as of 2019 and early 2020, was not in a position to implement Article 23. Given the political instability and the large-scale violence created by the extradition bill, it is almost impossible for Hong Kong government to introduce another bill, another controversial bill, another Article 23 bill into the legislature. So the central government decided to deal with the matter itself by forwarding this matter to the National People's Congress for consideration. And the National People's Congress enacted a decision, to deal with this so-called loophole in Hong Kong's national security law. So this is from the preamble of the decision, which stated that various unlawful activities, including advocacy for Hong Kong independence, violence, terrorism, had plagued Hong Kong, and there was a need in Hong Kong to introduce national security legislation. The decision also stressed that the introduction of national security law was actually essential to bring the practice of one country, two systems back to the right track. Without political stability and law and order, one country, two systems would not be able to continue to work. So, so after the decision itself authorized the National People's Congress to enact what we call the NSL. Now here you can see the general structure of the NSL, and because of time limitations, I will only very briefly introduce the issues which the NSL dealt with. Chapter 1 states general principles regarding the national security law, protection of national security and protection of human rights, the rule of law and the rights of the accused were all emphasized in Chapter 1. Chapter 2 provides for the constitutional responsibility of the Hong Kong SAR regarding national security, including the responsibility of the chief executive to the Central People's Government in this regard. It also set up several new institutions for the maintenance of national security in Hong Kong, including a National Security Committee chaired by the Chief Executive, and a new office called the National Security Office of the Central People's Government in Hong Kong. Chapter 3 of the law introduced several offenses relating to national security. There are basically 4 types of offenses. I will not go into them in detail. You can read them in Chapter 3, read about them in Chapter 3 of the NSL. The 4 types of offenses are, firstly, secession, which basically aim at acts to promote Hong Kong independence. The second kind of offenses relating to subversion, namely acts relating to overthrowing the Central People's Government, undermining the operation of the SAR government, changing, undermining the socialist system in mainland China, and so on. The third set of offenses relating to terrorism, which is actually quite common in other countries. Almost every country nowadays have anti-terrorism law, and the NSL in this regard is quite similar to other foreign laws on this matter. And then finally, there is an offense called collusion with foreign states for the purpose of endangering national security. Doesn't seem to work. Okay, collusion with foreign forces to endanger national security. This section actually deals with matters that arose during the anti-extradition movement, such as calling upon foreign states to impose sanctions on China or Hong Kong. And it also covers other matters like protection of state secrets from being leaked to foreign governments. The procedure for enforcing the NSL is also provided for in the NSL, and I think the other speakers in this session will be talking about different aspects of this procedure. So since I have already exceeded my time, so I'll finish here and leave it to the other speakers to deal with other remaining aspects.
Professor Cheng. We'll be coming back to questions. So may I now invite the next speaker, is Mr. Horace Cheng, to please present.
President of the Law Society, fellow panel speakers, distinguished guests, ladies and gentlemen, good afternoon. It's my great pleasure to join the Law Society's forum today and participate in this session on NSL. Since the NSL has come into effect in June 2020, stability and security have been restored in Hong Kong SAR, and providing business enterprises and investors with a secure environment to flourish. Nevertheless, we understand that some foreign investors still have concerns over the NSL, and today's session serves as an excellent opportunity for us to address those concerns and clarify misconceptions about the NSL. Before going into the details of the laws, it would be helpful to first understand that the NSL, unlike other legislation, is a national law and added by the Standing Committee of the National People's Congress. And I would like to highlight a few points in such regard. 1, national security concerns the core interests of a state and is undoubtedly within the purview of the central authorities. In other words, Safeguarding the national security is a matter within the purview of the Central People's Government and outside the limit of the Hong Kong SAR's high degree of autonomy. 2. Under the Article 12 of the NSL, the Committee for Safeguarding the National Security of the Hong Kong SAR is specifically created to be responsible for affairs relating to and assume primary responsibility of safeguarding the national security in the Hong Kong SAR. As affirmed by the Hong Kong Court of the first instance, the supervisory power over the committee is reserved to the Central People's Government exclusively, and that the Hong Kong SAR Court are not vested with any role or power over such matters. Number 3, as a piece of national law, the power to interpret the NSL is vested in the Standing Committee of the National People's Congress, as provided under Article 65 of NSL. This is in line with the Article 67 of the Constitution of the People's Republic of China, which provides that the Standing Committee of the National People's Congress shall have the power to interpret laws. Point number 4, although the NSL is a piece of national law, the Standing Committee of the National People's Congress has taken into account the differences between the legal system of mainland China and the Hong Kong SAR in formulating the NSL. And its provisions are designed to be compatible with and complementary to the laws of the Hong Kong SAR in order to ensure the effective implementation of the legal framework for safeguarding the national security in the Hong Kong SAR. Having looked at the nature of the NSL, let us now visit some of the misinformation about the NSL. One common misconception about the NSL is that it takes away the rights and the rule of law enjoyed by Hong Kong SAR. And let me put it straight. It is internationally recognized that rights and freedoms are not absolute. The two international covenants, that is the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, expressly provide that many rights and freedoms may be restricted for common good, including national security and public order. And during the adoption of the NSL, the relevant contents of the international covenants were fully taken into consideration in the legislative process, with an emphasis placed on the fact that the principle of human rights protection must be observed when safeguarding the national security. Other than misconception about the human rights and rule of law, there were concerns, especially raised recently, for the extraterritorial application of the NSL. And I would like to clearly point out the scope of application of the law, fully aligns with the principle of the international law and practice, and that such a practice is both necessary and legitimate. And let me explain the relevant legal principles. The NSL served the purpose of safeguarding the national security as well as preventing, suppressing, and imposing punishments for acts and activities endangering the national security. So a lack of extraterritorial effect actually means condoning activities such as secession and subversion carried out by ill-intentional people overseas. Therefore, extraterritorial effect is an essential component of the NSL. In general, the criminal law of the Hong Kong SAR only regulates acts that take place in the Hong Kong SAR and this is known as the territorial principle in the international law and practice. At the same time, international law and practice have also established exceptions to the territorial principles, including the personality principle and the principle of protective jurisdiction. Every state has the right to formulate laws based on these principles to exercise jurisdiction over criminal acts committed outside its territory. The NSL, formulated by the central authorities, defines the scope of application of the law precisely in accordance with these principles of international laws and practice. As regards the territorial principle, Article 36 of the NSL stipulates that this law shall apply to offenses under this law which are committed in the Hong Kong SAR by any person. And the offense shall be deemed to have been committed in the region if an act committing the offense or the consequences of the offense occurs in the region. This provision is directed at criminal acts that are wholly or partially committed in the Hong Kong SAR and reflects the territorial principle. Under certain situations in line with the international law and practice, the criminal law may regulate acts that take place outside the Hong Kong SAR. The NSL provides for two types of situations as follows. The first type of situation concerns an offender whose identity has close connection with the Hong Kong SAR, rather than a foreigner who has absolutely low ties with the Hong Kong SAR. And this is known as the personality principle. And under this principle, a state may exercise jurisdiction over criminal acts committed by its citizens outside its territory. As a matter of fact, every citizen or permanent resident of a country or region shall abide by the laws of the country or region regardless of where he or she is. The second type of situation arises when the criminal acts go against and undermine the security or the vital interests of Hong Kong. And this is the principle of protective jurisdiction. And under the principle of the protective jurisdictions, if foreigners commit criminal acts abroad against a sovereign state that endangers its security or its vital interests, such as the government systems or functions, the sovereign state can adopt laws with extraterritorial effect to exercise prescriptive criminal jurisdiction. It is the inherent right and obligation of our country as a sovereign state to enact the NSL as well as to exercise extraterritorial jurisdiction over the relevant offenses endangering national security. It is the constitutional duty of Hong Kong to safeguard national security, and the Hong Kong SAR government would spare no effort to take all necessary measures in accordance with the law and to pursue the liability of those who have committed offense under the NSL outside Hong Kong. To conclude, notwithstanding some unfortunate misconceptions, the enactment of the NSL is in line with the international practice of safeguarding national security and the sovereign rights of each state. Hong Kong's legal system and rule of law remain robust, providing quality and reliable legal support for international trade and investment. On such a note, I look forward to the insightful views of the other panelists and our further exchanges today. Thank you.
Thank you very much, Horace. I now invite Mr. Grenville CROSS to present his short speech.
Good afternoon, ladies and gentlemen. I'm grateful to the President of the Law Society for inviting me to participate in today's forum, and I will share with you my thoughts on how the judiciary has conducted itself under the national security law. And I will, for the benefit of those who are not familiar with our judicial system, provide a context. Now, both before and after the reunification in 1997, Hong Kong's greatest asset has been the rule of law, operated by an independent judiciary. It is fortunate to have one of the most professional judiciaries in the Asia-Pacific region, and its judges are invariably of the highest caliber. Whereas before 1997, judicial independence was purely based on convention, it is now guaranteed by the basic law, the city's mini-constitution, which stipulates that the court shall, quote, exercise judicial power independently, free from any interference. And what this means, therefore, is that the city's judges now operate from a secure base, that is, for the first time, constitutionally protected, and this is obviously reassuring for them. They dispense justice impartially, and they have enjoyed public confidence for the way in which they have ensured the continued success of the legal system after 1997. This is why, for example, in the World Justice Project's Rule of Law Index for 2022, Hong Kong was ranked 22nd out of the 140 places surveyed, ahead, for example, of the US at 26th, Italy at 32nd, and Greece at 44th. This, of course, was no mean feat, and the judiciary deserves great credit for it, particularly the Hong Kong Court of Final Appeal. As the successor to the Judicial Committee of the Privy Council, the Hong Kong Court of Final Appeal oversees the legal system and currently comprises 4 distinguished local judges and 11 eminent overseas jurists from other common law jurisdictions. Its overseas members, who sit as non-permanent judges, include two former Chief Justices of Australia, Robert French and Murray Gleeson, the former Chief Justice of Canada, Beverley McLachlan, and 2 former Presidents of the UK Supreme Court, Lords Phillips and Neuberger. The Court's judgments are invariably impeccable and are often cited with approval elsewhere in the common law world, which, given its expertise, should surprise nobody. Whereas one of its jurists, the UK's Lord Sumption, has explained how the NSL, quote, guarantees human rights. Another, Canada's Beverley McLachlan, has said, quote, the court is completely independent and functioning in the way I was used to in Canada. She also observed, there's no government influence, and if there were, I wouldn't be there. Now, although this positivity is the last thing that those who claim that the rule of law is on its last legs want to hear, it is immensely reassuring for the people of Hong Kong who trust their courts. Indeed, the court's latest recruit, who was appointed earlier this year, is the former Chief Justice of the Federal Court of Australia, Patrick Keane. When asked about his appointment, he explained how successful the court has been in defending the rule of law. Quite clearly, jurists of this quality would not be serving in the Court of Final Appeal if the NSL had in any way affected their capacity to administer justice and uphold the rule of law. Now, let me say something briefly about the NSL trials and common law procedures. In national security trials, the roles of the participants are exactly the same as in other criminal trials, and the system is firmly based in the common law tradition. Whereas suspects enjoy the presumption of innocence, prosecutors only bring charges if there is a reasonable prospect of conviction on the evidence and it is in the public interest. At the trial, the accused is entitled to the services of legal counsel, and he can cross-examine the prosecution witnesses and give and call evidence on his own behalf. There can only be a conviction if the prosecutors have established guilt beyond a reasonable doubt, a high threshold. And then, if convicted, the convicted person can, as provided by the International Covenant on Civil and Political Rights, which is specifically protected by the NSL, as one of my colleagues mentioned, challenge the conviction and sentence by an appeal to a higher court, up to and including the HKCFA. Now, let me deal with the issue of designated judges. One of the NSL's provisions involves the choice of judges to try national security cases. The NSL requires the Chief Executive to designate judges to, quote, handle cases concerning offences endangering national security. It has been suggested that this means that only judges will be selected who can be relied upon to convict, but this could not be further from the truth. Every designated judge comes from the existing judicial ranks and will already have established his or her credentials. Under the Basic Law, the Chief Executive appoints judges on the recommendation of an independent body, the Judicial Officers Recommendation Commission, chaired by the Chief Justice. The Basic Law further stipulates that judges and other members of the judiciary shall be chosen on the basis of their judicial and other qualities. The Recommendation Commission has itself particularised the qualities required for judicial appointment. They include honesty, integrity, industry, independence and intellectual capacity, outstanding competence as a lawyer, and professional excellence, mastery of facts and law, vision, drive and leadership qualities, and an ability to work with others and command respect. Once, therefore, a judge has passed through all these processes, he or she will be qualified to undertake whatever cases are assigned, although some judges will obviously be more talented than others. What this means, therefore, is that judges are selected without regard to politics and on the basis of their character. When judges are, as in Hong Kong, selected by an independent body, it promotes respect for judicial authority. All judges designated to handle national security cases would have been carefully vetted by the Recommendation Commission before they were first appointed to the judiciary, and they would have excelled thereafter in their judicial careers. Since the Chief Executive, as a non-lawyer, will know little, if anything, about the qualities of the various judges, it follows, as the NSL envisages, that the Chief Justice is consulted during the designation process. Those designated who serve for 1 year, which may be extended, are not, as some people imagine, a special breed, but come from the existing judiciary where they will have proved their worth. As the former Chief Justice, Geoffrey Ma, explained when the national security law was enacted in 2020, the only criteria for the appointment of designated judges are their judicial and professional qualities. And this means, he said, quote, judges should not be designated on the basis of any political considerations. It is noteworthy that judges of foreign nationality are not excluded from being designated judges, which is remarkably open-minded and certainly does not happen elsewhere. And once designated, judges adhere to their judicial oath, which requires them, quote, to administer justice without fear or favour, self-interest or deceit, just as they do in all other criminal cases. Given their extreme sensitivity, national security cases are only handled by judges of the highest quality. They will need to have demonstrated expertise, judgment and professionalism, and those judges designated so far have invariably proved their worth. As some national security cases involve highly sensitive material, the NSL provides, as an elementary precaution, that a judge will not be designated if he or she has made any statement or behaved in any manner endangering national security. Quite clearly, cases which may involve the nation's very survival cannot be handed out to any Tom, Dick or Harry, and they must be entrusted to the very best of the city's judges, by which I mean judges of the highest quality with a proven track record for excellence. This is now happening, and nobody need feel concerned. Now let me deal with the issue of the 3-judge panels. Although jury trials are the norm when serious cases are transferred to the Court of First Instance of the High Court, there has never been a right to trial by jury in Hong Kong, and most cases indeed are tried without a jury. The NSL recognises that circumstances can arise whereby a jury trial is not in the interest of justice. Although a jury trial is certainly possible, there are situations in which another means of achieving justice is necessary, and it does not affect the fairness of the trial. Where, therefore, the Secretary for Justice issues a certificate directing that the accused be tried without a jury on, quote, the grounds of, among others, the protection of state secrets, involvement of foreign actors in the case, and the protection of personal safety of jurors and their family members, the NSL provides that the case will be tried, quote, in the Court of First Instance without a jury by a panel of 3 judges. Now, after the Secretary of Justice has issued the certificate, that is normally the end of the matter. Once the Secretary concludes, for example, that the jurors or their family members are under threat and that a fair trial is no longer possible, the only realistic remedy is a non-jury trial by a 3-judge panel. The Court of Appeal explained in Tong Yin Kit's case, which involved the first NSL trial, that the Secretary's decision is a prosecutorial decision within the ambit of the Basic Law, which stipulates that the Department of Justice shall control criminal prosecutions free from any interference. Indeed, as I mentioned earlier, most cases in Hong Kong are tried by a judge or a magistrate sitting alone in the lower courts, and it would have been perfectly consistent with that practice for the NSL's drafters to have decided that the national security trials in the Court of First Instance would also be tried by a single judge, and nobody could seriously have complained. However, in their wisdom, and undoubtedly to allay concerns, the drafters decided that if a national security case was not to be tried by 7 jurors, that a 3-judge panel was the preferred alternative, undoubtedly reasoning that, as in the Court of Appeal, 3 heads are better than 1. If, moreover, a party is aggrieved by a decision of the Secretary of Justice to issue a certificate dispensing with a jury trial, it can be challenged by means of a judicial review in some circumstances. And these arise if it can be shown that the decision was taken in bad faith, or it resulted from an unlawful prosecution policy, or it was otherwise perverse. So safeguards exist against possible abuse. Now, ladies and gentlemen, although the NSL's three-judge panel provision has attracted criticism, it has rarely come from people unfamiliar with developments in other common law jurisdictions. After all, Hong Kong's legislation is by no means unique. And for example, in the UK, the Criminal Justice Act of 2003 allows a trial to be conducted by a judge alone if it is decided there was a real and present danger of jury tampering, and that once steps are taken to neutralise the threat, those threats cannot be neutralised. In Northern Ireland, single-judge trials were introduced in 1973 for terrorism-related cases, and at one time, over 300 such trials were being conducted a year. In 2017, for example, the last figure I was able to locate, the DPP issued 22 certificates for non-jury trials. In Ireland, as well, juries can be dispensed with, and the Constitution allows Parliament to establish special courts with wide powers when the ordinary courts are inadequate to secure the effective administration of justice. And when a case is tried by the Special Criminal Court in Ireland, there is no jury, and the defendant, as in Hong Kong, is tried by a three-judge panel. The DPP decides if a case should be tried by the SCC, and is not required to provide reasons. However, even during the so-called troubled ended with the Good Friday Agreement of 1988, the SCC has not only continued to operate, but has expanded its jurisdiction into other areas. It now handles not only national security cases, but also cases that endanger the administration of justice, as where jurors face intimidation, and cases involving serious and organised crime. Quite clearly, this goes way beyond anything possible under Hong Kong's NSL, yet it is rarely mentioned. In New Zealand, likewise, and in Australia, single-judge trials are permitted instead of juries. The European Convention on Human Rights has recognised that jury trials are not required to ensure fair trials, and it's also illuminating to briefly consider what role the juries have played in 3 other British colonies. I hope I might be allowed 1 or 2 more minutes just to deal with that.
Please complete that.
Yeah.
Thank you.
Which are geographically close to Hong Kong. In Singapore, the legal system is also based on the English common law, but trials, whether involving national security or other types of crime, are conducted by a single judge, with trial by jury having been abolished in all cases in 1969. Singapore also retains the death penalty, and the authorities can deploy preventive detention of up to 2 years in national security cases, and this may be renewed. Judicial review of decisions taken under the Internal Security Act are only possible to ensure procedural compliance, and Singapore, unlike Hong Kong, has not signed up to the ICCPR. In Malaysia, the legal system is predominantly based on the English common law, although there are also secondary legal systems affecting particular areas such as Islamic law and customary law. As in Singapore, trials, whether involving national security or other types of crime, are conducted by a single judge, with trial by jury having been abolished altogether in 1995. Provision is also made for the preventive detention of suspects and for the denial of bail to those charged with national security offences. The death penalty still exists, and the country is also not a party to the ICCPR. In Brunei, Darussalam, the legal system is based largely on the English common law, and there is also a Sharia court that deals with Islamic law cases. Trials of whatever type are conducted by single judges without juries, and the courts can impose the death penalty. As with Singapore and Malaysia, the country has not adopted the ICCPR. It is paradoxical, is it not, that those elsewhere who complain loudest about non-jury trials in national security cases and the Court of First Instance in Hong Kong never have a word to say about non-jury trials in Australia, Brunei, Ireland, Malaysia, New Zealand, Singapore, or the United Kingdom. As to why that is, please feel free, in an era of great global rivalry, to draw your own conclusions. When viewed comparatively, therefore, it is clear that Hong Kong's jury restrictions are limited and reasonable. They ensure that trials cannot be corrupted or otherwise undermined, and this, whatever critics may claim, is in the public interest. The use of 3-judge panels has not affected the fairness of the trials, and just outcomes remain the objective of the judiciary in all the cases it handles. Now, to conclude, Although some of the NSL's provisions concerning the judiciary are novel, the legal system has successfully accommodated them. The fundamental principles of criminal justice have not been affected, and national security trials are fairly conducted along traditional lines. The judiciary has assimilated the new procedures and has not had to compromise its basic values in doing so. The NSL has not only proved Hong Kong's salvation after the turmoil of 2019-2020, but has also provided mechanisms for the trying of cases that are realistic and fair and facilitate just outcomes. Now, in one capacity or another, I've been involved with Hong Kong's legal system for 45 years, and I can assure everybody that its judiciary is as experienced, as independent, and as professional today as it has ever been. And this means that the rule of law is in safe hands. Thank you very much.
Thank you very much, Grenville. Professor Chen, you may want to know that Grenville's the only person that can finish a thesis in 15 minutes. With that, may I please invite the Secretary for Security, Mr. Cheng, please.
Dear friends and distinguished guests, I'm delighted to share my views with friends in Hong Kong and abroad in respect of the factual account of the Hong Kong SAR's work on implementing the national security law. As people of Hong Kong can see, after the implementation of the NSL, stability and security has been swiftly and effectively restored. And as those of you who were in Hong Kong during the Black Flag violence in 2019 may recall, members of the public who held different views were tied up, falsely imprisoned, and assaulted by rioters, and shops and public facilities were vandalized. For many of you, it was not possible to do business in Hong Kong at that time. The whole scene was never peaceful or a simple expression of opinions as some overseas media and politicians attempt to portray. The NSL effectively restored the enjoyment of rights and freedoms which many people of Hong Kong, either locals or from overseas, have been unable to enjoy during the period of the Black Cat violence. People living and business operating here in Hong Kong are relieved and happy to see Hong Kong now continue to be an open, safe, and business-friendly city. However, many overseas media and politicians have been turning a blind eye to these facts and achievements by the Hong Kong SAR government in restoring the law and order. And they have been laying false claims on the NSL, and one of the false accusations is that the Hong Kong SAR government has been stifling dissent and persecuting opposition using the law, and rights and freedoms of people of Hong Kong have been undermined. As the Secretary for Security, it is my responsibility to clear up these claims so that the international community, in particular the business community, will not be misguided. These claims are simply untrue. The truth is, all law enforcement action taken by the law enforcement agencies are based on evidence strictly according to the law and for the facts and for the acts of the people or the organizations concerned, and nothing more, not because of their political background. Since the implementation of the NSL, as regards cases involving suspected acts and activities that endanger national security, and as at last week, 265 people were arrested, with 101 persons and 5 companies were charged in the cases concerned. All of the 80 persons who have their case trialed by our independent and impartial court so far were convicted. And after reading the relevant court judgments, one would no doubt agree that the prosecution case has been well supported with evidence, and credit is due to our colleagues in the Department of Justice. And our courts have reviewed all evidence and adjudicated in accordance with applicable laws in an impartial and fair manner. Some foreign media and politicians went on to suggest that certain arrestees should be released and charges should be dropped because of their status. Such proposition is totally unfair. Under the overarching principle of rule of law and equality before the law, it would be a hypocritical argument of politics overriding justice for anyone to advocate privilege for a certain group of people, such as media tycoon, and contend that they are above the law and should be immune to legal sanctions despite violating the law. Whether or not a person should be acquitted and hence released should be decided by the court based on facts and the law, and definitely not because of his or her background or political affiliation or whatever power is behind them. This, I believe, is the same standard held around the world. As regards claims that the freedoms and rights of people of Hong Kong have been undermined by the NSL, and all measures or enforcement action taken to safeguard national security must observe the principle stipulated in the NSL, which, as the Deputy Secretary for Justice had already mentioned, provides that human rights should be respected and protected in safeguarding national security in Hong Kong, and the principle of the rule of law should be adhered to when enforcing NSL. The Hong Kong SAR is particularly the law enforcement authorities and the judiciary ensure that rights and freedoms are protected in accordance with the law. The courts have been adjudicated upon a number of legal challenges on enforcement action. A conscientious reading of the judgment will reveal that the courts have given due consideration to the rights and freedoms protected by the Basic Law and provision of the ICCPR as applied to the Hong Kong SAR, and struck a reasonable balance between the protection of national security and the protection of rights and freedoms. It follows that the NSL does not affect the legitimate rights of the Hong Kong residents to exercise their fundamental freedoms and rights, including criticizing government policies or policies and decisions made by officials. Neither will freedom of information, academic freedom, policy studies, personal data privacy, and general business activities be compromised. It should be stressed, however, that these freedoms are not absolute. The two major international covenants on human rights, i.e. the ICCPR and the ICE-SCR, both permit restriction if they are prescribed by law and for the protection of national security. And this is not something invented in Hong Kong, and this is a common practice in countries around the world. At times, there have been calls from foreign powers that the NSL in Hong Kong be repealed. Such calls, in my view, are totally untenable. As a matter of fact, laws in safeguarding national security are not something unique in Hong Kong, and every jurisdiction will enact laws on safeguarding national security. And this is an inherent right of every sovereign jurisdiction. The United States has at least 20 relevant items of such laws. Canada, Australia, New Zealand, UK, etc. also have their own national security laws. As many of you may be aware, the Home Secretary of the UK introduced in 2022 the National Security Bill into the UK Parliament. The bill is right-range, highlighting national security risks from foreign states, including espionage, foreign interference in political systems, sabotage, disinformation, cyber operations, etc., and expressing the need for the UK to legislate to get ahead of these threats. The UK bill introduced a series of new offenses of very wide range coverage. For example, new offenses of sabotage and foreign interference to guard against state backed sabotage against critical sites, data, and infrastructure, and a number of measures empowering the UK police to detain arrested person without charge for a maximum of 14 days, and the Secretary of State to impose in a targeted manner state threat prevention and investigation measures on individuals whom the Secretary of State reasonably believes to be involved in foreign power state threat activities. And such restrictions cover a myriad of aspects, including residence, travel, entry into area or places, movement, use of electronic communication device, financial services, work or studies, etc. And even a requirement to participate in polygraph sections. And the vast majority of the offenses proposed in the bill have extraterritorial application, and regardless of the nationality of the person or place of establishment of the organizations committing the offense. The above is just an example in the national security legislation scene worldwide, and the call for repeal of NSL in Hong Kong only illustrate the bias and double standard of foreign powers. That naturally takes us to the issue of the need to further enhance our laws in safeguarding national security. And although the social order has been restored after the implementation of the NSL, national security threats remains, and just like other places in the world. It would be too naive to think that national security threats to Hong Kong would be gone for good. To the contrary, activities of the criminals have gone increasingly underground, and there are also elements endangering the security of both the state and Hong Kong, and who have absconded overseas, wantonly colluded with external elements, and continued to engage in acts and activities endangering national security, such as disseminating message of separating Hong Kong from our country. So the enactment of local legislation on Article 23 of the Basic Law is not just a constitutional responsibility of the Hong Kong SAR, but there are also practical needs to do so. Ladies and gentlemen, and I hope the above would help clear some misconception on the implementation of NSL, and in fact, stability and security and prosperity and development are complementary to each other. Business operations can only run effectively in a place with social stability firmly secured, and the continued implementation of the NSL is essential in enabling us to ensure the continued stability and prosperity of Hong Kong, and also its ability to seize the unlimited opportunity offered by our mother country. Thank you very much.
Thank you very much, Mr. Cheng. Setting out the principles, conditions. Thank you very much. So now it's time for question and answers. I haven't got any question and answers on the board. So may I start with Professor Chan? Can I just ask you, just very quickly, what are the mechanisms for protection of human rights under the NSL?
As I mentioned in my speech, Chapter 1 of the NSL itself expressly refers to the need to protect human rights in addition to the protection of national security. It also mentions the principles of the rule of law and protection of the rights of the accused. In practical terms, the NSL and other laws in Hong Kong relating to national security define precisely the scope of the prohibited acts, including certain types of speech. So, so long as a resident in Hong Kong does not do anything that violate these provisions, do anything which is prescribed by these provisions, the resident is free, completely free in his or her actions. This is the principle that in the common law system, we can do anything that is not prohibited or disallowed by law. So that is the scope of liberty. Other speakers have mentioned that some countries have national security laws that authorize preventive detention, namely detention of somebody on the ground that he or she is a threat to national security without specifying what criminal offense he or she is suspected of having committed. That is no preventive detention under Hong Kong's national security law. Anyone who is arrested on the basis that he or she is suspected of having committed an offense provided for in the national security law or in any other relevant Hong Kong law. The arrested person has to be brought to a court within 48 hours, and it is up to the court to decide whether that person is to be granted bail or will have to be kept in custody pending trial. I think will another speaker be talking about bail?
Yes, will anyone be talking? No, you can. I think yes, you can carry on.
Yeah. So there is a provision in the NSL providing for a higher threshold for bail, but that doesn't mean that people cannot get bail in national security cases. In practice, a fair percentage of defendants prosecuted under the NSL have been granted bail, although a greater number, the majority, have failed to meet the higher threshold for bail under national security, under the national security law. Mr. Grenville CROSS has already talked about the judicial process, ensuring the rights of defense, the participation of defense lawyers, and the independence of the judiciary. So these are all safeguards for the rights of the accused in the criminal process, including the right to appeal and so on. Ultimately, every country, the laws of every country try to strike a balance between human rights and protection of public interest and national security. So Hong Kong's national security law has tried to do the same. And as compared to some countries' national security laws, which provide for a very wide range of offenses and even powers of preventive detention, Hong Kong's national security law cannot be regarded as particularly harsh. So maybe that's what I would say at this point.
Professor Cheng. Okay, now the next question to Horace. You talked about extraterritoriality of national security law just now, and that such application of the law is in line with the various countries and regions around the world. In fact, Grenville's covered some of this herself. But could you elaborate a bit more from what you were saying, from your perspective of extraterritoriality?
Yes, sure. Actually, the extraterritorial application, it is a common feature of the NSL in various countries. Just name a few: the United States, the United Kingdom, Australia, Canada, and the member of the European Union. They all have the extraterritorial effect under the principle of personality and the principle of protective jurisdiction. I could be more specific. We can see the application of the personality principle in the offense of treason and the offense of unlawful disclosure of classified information and the Logan Act in the United Kingdom. We can also see the application of this principle in the offense of treason and the Terrorism Act 2000 in the United Kingdom. We can also see the application of this principle in the offense of treason in Canada and in the offense of the dissemination of propaganda material in Germany. And on the principle of protective jurisdiction, we can also see a lot, many examples of its application in many jurisdictions, such as terrorism offenses in the United States, the National Security Bill, which is currently at the final legislative stage in the United Kingdom. And also we can see that in Canada and Germany. So in conclusion, actually the extraterritorial application is a very, very common feature of the NSLO in almost all jurisdictions, common law jurisdictions.
So for those businessmen who wish who asked the question, is it okay for me to continue business in Hong Kong? The answer is the same as would you continue business in any other jurisdiction which has NSL? Can I just ask you one more question, which Professor Chen has covered in one aspect, but I think the aspect is there is a lot of misinformation that the defendants charged with offenses endangering national security are all denied bail because of NSL. And from this perspective, from what Professor Chen said, is whether this constitutes a derogation from the presumptions of innocence.
Yeah, it is a misconception. And contrary to this misconception, is actually a matter of fact that, as mentioned by Professor, a number of defendants have been released on bail after the court duly considered the requirements as stipulated in the NSL and the relevant local laws. For example, as reported by the media, some defendants, including the former legislators who were charged with the national security offense, are currently released on court bail. When we are talking about the bail under the NSL, actually we are talking about the paragraph 2 of the NSL Article 42, which states that no bail shall be granted to a criminal suspect or defendant unless the judge has sufficient grounds for believing that the criminal suspect will not continue to commit acts endangering national security. And according to the Court of Final Appeal, in the case of Lai Chi-ying, actually the Article 42 of NSL creates a specific exception to the Hong Kong SAR rules and principles governing the grants of the bail, and import a stringent threshold requirement for bail application. So if having taken into account all relevant material, the court concludes that it does not have sufficient grounds for believing that the accused will not continue to commit the act endangering national security, the bail must be reversed. If, on the other hand, the court concludes that taking all relevant materials into account, it does have sufficient grounds, then the court should proceed to consider all other matters relevant to the grants of bail under the Criminal Procedure Ordinance as usual. So I would say the Court of Final Appeal takes the view that it is the primary purpose of the NSL to safeguard the national security and to prevent and suppress any act that endanger the national security. So it explains why the NSL introduces more stringent conditions to the grant of the bail in relation to offense endangering national security. And at the same time, the Court of Final Appeal points out that the court's decision as to whether to grant the bail actually is a juridical exercise carried out by the court as an exercise in the judgment and evaluation and not the application of a burden of proof, which indicates that while the NSL has put in place a stringent threshold for the grant of bail for cases concerning offense endangering national security, this does not violate the principle of presumption of innocence.
Thank you, Horace. Very succinct, very complex issue, very succinctly put. Thank you very much. Grenville, can I ask you a more difficult question? Was the resignation of the two serving UK Supreme Court judges, Lord Reed and Lord Hodge, from the Hong Kong CFA in March 2022 because of the NSL a cause for concern?
Well, they were both very experienced judges, and it was a pity they felt they had to resign. But it always struck me there was something very fishy about the whole thing. You may remember that in late 2021, the same two judges conducted a review of their situation in the Court of Final Appeal, and they decided they would stay. Just over 6 months later, they suddenly changed their minds and decided they would resign. Nothing of any great significance had occurred between the two events, and the only significant thing that I was able to see was the statement by the then Foreign Secretary, Liz Truss, who said that the British government had taken the view that it was untenable for serving British judges to remain in the Court of Final Appeal, and that she was therefore withdrawing support for those judges to remain there. So it became crystal clear to me that pressure had been put upon those judges to resign. And of course, even though they could put pressure on those two judges, because they were still on the government payroll, still serving judges, they were unable to pressurise the other 6 British judges who've all remained, of course. So the real story in my mind is not so much that 2 resigned, but that 10 others, including the Australian judges and the Canadian judge, all decided to remain. And of course, as I mentioned in my remarks just now, Hong Kong has recruited an extra judge for the Court of Final Appeal as recently as January, Justice Patrick Keane from Australia. So that is the real story, that we still have 11 judges of the highest caliber, and not that 2 fell by the wayside.
Yes. I've also, when I was in Paris, asked by a Canadian lawyer, are your judiciary independent? You know, do you have the best caliber judges? And I said, well, we have a Canadian judge on our Court of Final Appeal. They said, really? So you can see we need to clarify a lot of misapprehension across the world. And
there won't be any misunderstanding. Those judges have also come under pressure to resign. But as they are all retired judges, they're able to exercise their own judgment in the matter, and they've all elected to remain. So I think, as I say, that is the real story, that these judges have chosen to stick with Hong Kong, and they've chosen to do so, as I mentioned in my speech, because they are satisfied that the legal system is working satisfactorily.
And they're independent in their own assessment and judgment.
Well, as Justice McLachlan from Canada said, if there had been any interference or there were any problems, I would have packed my bags and left.
Exactly.
But there aren't.
That's what you expect from the members of the highest caliber of the judiciary. Can I just also ask, will the restrictions on foreign lawyers appearing as defense counsel in NSL cases adversely affect the rights of defendants in to a fair trial?
Well, absolutely not, but I think a bit of context is required for your question, because not everyone may understand our system. Under our system, partly for historical reasons, but also because Hong Kong is an international city, overseas barristers are allowed to apply for admission in Hong Kong cases. And they are normally admitted if there is no suitable counsel available locally with the necessary expertise to do the case. Some are rejected, but some are admitted. Now, this practice, as I say, is partly for historical reasons and partly because Hong Kong is an international city. But in national security cases, there are particular concerns because overseas lawyers who are admitted, if they are admitted to do these type of cases, will learn highly secret information about the way in which the national security police operate, and indeed other state secrets. And even though there is a provision, I think it's Article 63 of the National Security Law, which requires lawyers to protect national security information, it can't obviously be enforced against overseas lawyers who've returned from their home jurisdiction and may be asked by the authorities in their own country to disclose what they've learned. But having said that, there are 2 other points that need to be made. It's not every foreign lawyer every overseas lawyer who is excluded. if the chief executive takes the view that there's no particular worry about having an overseas lawyer conduct a case, then they can be admitted. So it's not a blanket approach, it's a case-by-case approach. And the other point that needs emphasising is that the foreign lawyers who live and work in Hong Kong are not affected by the limits at all. They are allowed to do national security cases, which is a remarkable situation. I mean, it doesn't happen in other countries. And just as in other countries, it doesn't happen that overseas lawyers are allowed to come and appear in the courts. I mean, it's sometimes suggested there is, as you know, in the basic law, a provision that says that accused persons can have lawyers of their choice. But that certainly doesn't mean lawyers from other jurisdictions. What it does mean is lawyers who are qualified to practice in the particular jurisdiction here in Hong Kong, so they can have a local lawyer or they can have a foreign lawyer who is resident in Hong Kong. And of course, it's quite remarkable that Hong Kong does operate this system. Certainly the UK, United States, Canada, these other places, Australia, they don't allow foreign lawyers to come in and do cases there. And it's a remarkable feather in Hong Kong's cap that it does do so.
And for our business community, what you should reaffirm is that as far as non-NSL cases are concerned, clients who wish to instruct foreign lawyers to do their cases are free to do so. Well,
that's completely unaffected by the change. We're only concerned with national security cases which have a particular sensitivity and where there are real concerns that the information that the lawyer might acquire might end up in the hands of people who are hostile towards Hong Kong.
That's your justification. Yeah, thank you very much, Grenville. And I may ask some questions from Mr. Tang, Secretary for Security. There have been criticisms that the national security law has led to the disbandment and closure of many organizations in the civil societies. Will that affect the business sector investing in Hong Kong?
My response to your statement is simply no. I think what the NSL seeks to prevent and target are those acts and activities that endangering national security and which are distinctly different from normal interactions. And in no way, normal business activities will be affected. And since the implementation of the NSL, we have indeed seen many organizations suspected of endangering national security end up in dissolution or ceasing operations. But the closure of some was actually the result of action taken by the government under the law. And for those organizations that have disbanded or ceased operation voluntarily, right? And in many of them, their responsible persons were later been arrested and prosecuted for offenses endangering national security based on evidence. And it goes without saying that these organizations were related to acts and activities endangering national security, and as opposed to organizations that simply pursuing legitimate aims and carrying out business activities. And in fact, I would say on the contrary, the implementation of the NSL has reverted the chaotic situation and serious violence earlier and restored stability and security, and that increased the confidence in Hong Kong and thereby enabling business operation and activities to resume normal in Hong Kong.
Thank you very much. Can I just, final question. Professor Chen started off with Article 23 in his talk, but given that the NSL has been implemented and order restored in Hong Kong, is there still any strong reason for the government to continue to pursue legislation on Article 23 of the Basic Law?
I think enacting local legislation on Article 23 of the Basic Law and to refine laws relevant to safeguarding national security are our constitutional responsibility. And besides, I think there are also practical needs to legislate on Article 23. And given Hong Kong's unique environment and lifestyle under the principle of one country, two systems, and as evidenced by the Black Cat violence back in 2019, and it is easy for external elements to infiltrate with malicious intent or even attempt to to foment color revolution, subvert the state power, as well as to promote and advocate Hong Kong independence and thus intensify national security risks. Among the 7 types of acts which the Hong Kong SAR shall enact law to prohibit as prescribed in Article 23, 2 are covered by the NSL, i.e. secession and subversion. The other 5 acts are only partly covered by existing local legislation. And we need an act law to not only handle, but also to prevent acts of espionage, sabotage, and infiltration by foreign forces. And the Hong Kong SAR government has been taking forward relevant work in respect of the enactment of legislation on Article 23. Apart from reviewing existing laws and examining relevant national law, as well as laws of similar nature in other jurisdictions, and we are also reviewing the changing national security risks that we are facing, in particular those identified in the 2019 Black Cat violence, implementation experience of the NSL, the relevant court verdicts, and deficiency of the existing law, as well as taken into account what has happened in the past. Thank you.
Thank you, Mr. Cheng. I'm concerned about the time. I was supposed to finish at 5:45, a bit run over. I've got 2 questions, but I don't think we have time. One of them we've already covered about the first mechanism. So with that, I think I'll take this opportunity to thank Professor Albert Cheng, Mr. Horace Cheung, Grenville CROSS, and Mr. Tang, Secretary of Security. Thank you very much for participating. Thank you.
Thank you very much for a very insightful sharing, and we now certainly have a better understanding of the topic. May I now invite Mr. NASIR to present the souvenirs to our speakers all together as a token of appreciation and take a group photo together.
I'm certain we all have acquired some very useful takeaway from today's 4 sessions. Today's forum will soon come to an end. We have the honor to have with us this afternoon the Honorable Christopher Ho Ching Yu, GBS, JP, Secretary for Financial Services and the Treasury, the government of the Hong Kong Special Administrative Region. In a moment, Mr. Ho will share with us his closing remarks for this forum.
Before we hear from Mr. Hui, may we now invite Mr. Hui to come on the stage to be joined by Mr. CM Chen, President of the Law Society of Hong Kong, and Mr. Ronald Sum JP, Council Member and Chairman of the Forum Organizing Committee for group photo.
Thank you, Mr. Hui, Mr. Chen, and Mr. Sum. Would Mr. Hui please remain on stage? Mr. Chen and Mr. Sum, please be seated.
May we now invite Mr. Hui to give his closing remarks. Mr. Hui, please.
CM, distinguished guests, ladies and gentlemen, Good afternoon. As we draw nearer to the conclusion of Law Society of Hong Kong's forum, focusing on Hong Kong's unique strengths and opportunities for international businesses, I trust you have all benefited from the collective expertise and diverse perspectives of this forum through a comprehensive exploration of key topics, including Hong Kong's legal system and business environment, opportunities in the GBA, and our city's status as an IFC. Today's rich dialogue reflects on Hong Kong's resilience and our ability to thrive on changes amid unusual times. As a wrap-up of today's discussion, even though I'm not here throughout the day, allow me to reiterate our strengths as an IFC, as well as the exceptional story presented by Hong Kong under the one country, two systems. The success of one country, two systems is unparalleled, and it serves as the backbone for developing our financial market. It allows our market to benefit from the strong support from our country, and at the same time maintaining seamless international connections. This synergy enhances the stability, reliability, and efficiency of capital formation and financial intermediation in our market, ultimately empowering real economic development for our city and our country. The one country, two systems framework is a crucial and integral part of our unique Hong Kong financial story, paving the way for our past success and continued development in the future. Over the past years, amid fierce regional and international competition, Hong Kong thrived as one of the world's leading IFCs with a full suite of financial services that are highly competitive, diverse, and trusted by investors worldwide. We owe our success to our country's solid support and our own unique geographical and institutional advantages that allow us to leverage the rapid development opportunities of our own country. Compared with other international financial centers, Hong Kong is distinctively, as we are, the leading international financial center of our country, which is the world's second largest economy, and our superconnector role under the one country, two systems is not to be found elsewhere. By serving as the bridge between the mainland and the rest of the world, connecting the capital markets and investors on both sides, we are bound to create more opportunities and benefits for countries and economies around the world. The convergence of capital and enterprises from both the mainland and the globe, coupled with the advantages brought about by the mutual access with the mainland's financial markets, have allowed Hong Kong to develop into a capital market with greater depth and breadth and more active trading activities that distinguish ourselves from other markets. Many institutional strengths define Hong Kong's advantages that have long propelled our resounding success. These institutional strengths include our independent judiciary, a market-oriented and globally centered business environment, internationally aligned regulatory regimes, and the free flow of capital and information. With these strengths, we have established our world-leading position in various segments of the financial market. Remarkably, recently the IMF released a staff report that reaffirms Hong Kong's status as a major international financial center. The report highlights our robust institutional frameworks, substantial capital and liquidity buffers, high-quality financial sector regulation, and a well-functioning linked exchange rate system. The IMF report is a recognition for our financial resilience and amid a volatile and challenging external environment. It also acknowledges the Hong Kong's government's efforts in bolstering our city's long-term economic and financial developments. Another key feature underlying our Hong Kong story is our firm commitment to the rule of law, which is the cornerstone of the trust and confidence needed by investors and corporates in doing business here. Our courts independently exercise education powers, and this ensures that there will be fair, objective, and impartial legal process for enforcing the law and the rules. Together with a deep pool of local international legal talents among all of you, and expertise in arbitration, as well as regulations and practices that align our international standards, we have established a friendly and trusted framework for businesses and investors. Our trusted legal system is all the more important for Hong Kong to function as an international financial center, and it has enabled us to develop a sophisticated market. Take the securities market as an example. Hong Kong possesses a deep and broad stock market, attracting investors from all over the world. As of end April this year, Hong Kong is the world's 7th largest and Asia's 4th largest stock market in terms of market cap, which amounts to $4.6 trillion. Last year, Hong Kong raised a total of $13.4 billion of funds through initial public offerings, continue to be one of the top fundraising hubs and leading biotech fundraising venues for companies from different jurisdictions. Hong Kong is also the top international banking hub in the region. As of end May this year, 74 of the world's top 100 banks are operating in Hong Kong. Hong Kong is also among the world's most open insurance centers. 12 of the top 20 insurers in the world were authorized to conduct business in Hong Kong. Meanwhile, Hong Kong is a leading bond hub in Asia. We have been the largest center for arranging international bond issuance in Asia for 7 consecutive years since the year 2016, capturing 30% of the market last year. We are also the largest hedge fund center in Asia. For PE, private equity, we rank 2nd in Asia after the mainland, with over $212 billion of assets under management. With the support of the Central People's Government, Hong Kong's status as the largest and the most important global offshore RMB business hub has continuously been strengthened over the years. As of end April this year, Hong Kong's RMB pool reached 984 billion RMB. We are handling about 75% of the total RMB settlements. We also offer an unparalleled list of mainland investment opportunities, including mutual market access programs such as the Stock Connect and Bond Connect, as well as risk management tools, including the A-shares index futures. The rule of law in Hong Kong has instilled trust and confidence among financial market participants and investors from all around the world. We set clear rules for our markets and participants, maintain high transparency of the functioning of the markets, and ensure the policies and practices are implemented in a consistent and predictable manner. Every day, the government and regulators monitor closely the markets, focusing on whether they are functioning orderly and properly, and whether there are systemic risks, irregularities, and vulnerabilities that will threaten Hong Kong's financial stability. We closely monitor the operation of financial infrastructure and market participants and ensure they are financially sound and resilient. Prompt and decisive actions are taken against financial crimes to maintain the integrity of our markets. Over the past few years, a number of mutual market access schemes have been launched, ranging from stocks and bonds to derivative products, with the introduction of Swap Connect in May this year. These have strengthened Hong Kong's status as the premier gateway for offshore investors to enter the mainland financial markets and further contributed to the two-way opening up of the mainland's capital markets to the rest of the world. Further to the inclusion of exchange-traded funds, i.e. ETFs, under Stock Connect in July last year, the exchanges in Shanghai, Shenzhen, and Hong Kong implemented further expansion of the scope of eligible stocks under Stock Connect in March this year, including the addition of eligible stocks of foreign companies that are primarily listed in Hong Kong. By introducing a channel to improve the liquidity of relevant stocks, the initiative could attract more quality international enterprises to list in Hong Kong and enhance the competitiveness of our fundraising platform. Separately, in June this year, which is last month, Hong Kong Stock Exchange launched the Hong Kong dollar dual counter model for specialized securities so that investors can trade securities of the same issuer in both Hong Kong dollar and renminbi and transact across the Hong Kong dollar and renminbi counters. By accumulating more experiences in key areas such as issuance, trading, market-making mechanism, and settlement of renminbi stocks in Hong Kong, this will pave the way for further development of the renminbi securities market. We will continue to make greater efforts to promote offshore renminbi business on various fronts, including collaboration with regulatory bodies to step up preparations of including renminbi trading counters in southbound trading of Stock Connect for early implementation. We are determined to expand the channels for cross-boundary renminbi flow, provide more investment and risk management products, and upgrade our related infrastructure to build an even more vibrant offshore renminbi ecosystem. To strengthen Hong Kong as an international risk management center, we've implemented in recent years a series of measures to promote diversified development of the insurance industry, including half-rate profit tax for specified insurance businesses, including marine and specialty risks, expanding the scope of insurance risks of captive insurance set up in Hong Kong, and enhancing the legal framework for group-wide supervision. We've also established a dedicated regulatory regime and pilot grant scheme for insurance-linked securities, facilitating 4 issuances of catastrophe bonds in Hong Kong, which secured protection against losses inflicted by typhoons and earthquakes in the mainland and overseas places. To promote mutual access of insurance markets, we've rolled out the unilateral recognition arrangement for cross-boundary motor insurance. We will also continue to strive for the establishment of after-sales service centers in places such as Nansha, Qianhai, and Pengqin to provide GBA residents holding Hong Kong insurance policies with comprehensive support services. To sharpen our competitiveness as an asset and wealth management hub, the government has enhanced the fund structures available to the industry, provided tax incentives, put in place a fund redomiciliation regime, broadened our fund distribution network, and offered a range of other financial incentives. In particular, we adopt a multi-pronged approach in attracting global family offices to set foot here in Hong Kong. We've published a policy statement in March this year to outline our vision and action plan to develop Hong Kong into a premier hub for family offices. And there are altogether 8 measures that we proposed, and I encourage all of you, as lawyers, to look at our policy statement in detail. The successful organization of the Wealth for Good in Hong Kong Summit, tailored for family offices, the provision of profit tax exemption for single-family offices investments, and the recent setup of a new network of family office service providers are all proactive efforts to demonstrate our commitment to creating a conducive and competitive environment for family offices and asset owners to thrive in Hong Kong. The government has also various initiatives in the pipeline to promote development of other emerging segments of financial market. In particular, we are working hard on furthering green finance development. Specifically, the Financial Secretary announced in the year 2023-24 budget that we will actively accelerate the development of Hong Kong into an international center for green tech and finance. These should bring more opportunities for Hong Kong's financial, business, and professional services sectors as we actively contribute to the global transitions towards green development. Looking ahead, I'm very optimistic about Hong Kong's outlook. In the short term, we face opportunities as well as challenges. But of course, opportunities far exceed challenges, especially when we cast our sight further to the medium and long term. The opportunities are vested in the fundamental unique strengths of Hong Kong under one country, 2 systems. We continue to practice common law, which is important to the international business sector. The linked exchange rate system, which has been operating effectively, will continue to operate. With no exchange control and maintain free flow of goods, capital, people, and data. Meanwhile, as our country continues to embrace high-level two-way opening up and strengthen collaboration with economies around the world for mutual development and common prosperity, we have an important role to play, and will continue to seize the unparalleled opportunities by leveraging our unique advantages as the bridge between the mainland and the rest of the world. Ladies and gentlemen, in a changing world, as the theme of this forum suggests, with our country's steadfast support, Hong Kong's future as an IFC is promising and bright with tremendous opportunities. But all in all, the key word to these is trust. We will continue to maintain and strengthen trust in our clear and transparent financial regulatory system, in our facilitating role for connecting mainland with the world, and crucially, in our rule of law and common law system. Rest assured, we will do our utmost to uphold it, and with our collective efforts, we'll continue to craft an exceptional story for Hong Kong. And before I closing, finally, I know all of you are lawyers, so I should give you an overview or some of the preview of some of the consultations that we will launch. First of all, I think we talk about GEM a lot, so we will soon launch consultation on GEM. At the same time, we are now drafting legislation to meet our international obligations in the EU arena, especially one concerning the foreign source investment income. So this is something that is to be looked out for. At the same time, next year, we will put together a redomiciliation regime for companies, which I'm sure many of you, potentially insurers, are most interested, among others. At the same time, we'll also put together a regulatory regime for stablecoin, which is more on the tech side. And perhaps I can share more next time if I'm invited on a more tech forum on this topic. So thank you, and have a good day.
Thank you, Mr. Ho, for your inspiring closing remarks. Last but not least, may I now invite Mr. Ronald Sum, JP, Council Member and Chairman of the Forum Organization Committee of the Law Society of Hong Kong, to give his closing remarks. Mr. Sum, please.
Distinguished guests, speakers, ladies and gentlemen, as the final speakers of the day, I'm going to keep this extremely short. On behalf of the Forum Organizing Committee and the Law Society of Hong Kong, may I express my sincere gratitude to you all for your support and participation in today's forum. As our President, CM, said this morning, the Law Society of Hong Kong is very grateful to have the opportunity of organizing this forum, which is our first face-to-face event in such a large scale since the resumption of normalcy. It is encouraging to know that over 2,100 participants from across the world have joined us today, over 51 jurisdictions, physically and virtually. In particular, I would like to extend my heartfelt thanks to the guests attending in person, especially from overseas and Greater China counterparts who traveled a long way to Hong Kong. I must also thank the Hong Kong SAR government's Professional Service Advancement Support Scheme, PASS, in short, our sponsors and supporting organizations for their unwavering support to our shared vision. The inspiring speeches of the Secretary for Justice, the Secretary for Innovation, Technology and Industry, and the Secretary for Financial Services and Treasury, together with the informative and engaging sharing by over 20 distinguished speakers, have been truly inspiring. Thank you very much for your time and expertise for making this forum a success. Changes can present challenges, and at the same time, opportunities. With Hong Kong's robust legal system, unwavering support of the rule of law, independent judiciary, and well-established financial infrastructure, as well as the abundant pool of talents from various sectors, including the legal professionals. We are confident that Hong Kong can continue to thrive and excel in legal, financial, and commercial activities. I must thank all the hard work of the members of the Forum Organizing Committee. They're the staffs of the Law Society of Hong Kong, too many to mention, and you know who you are. It was them who make this forum run smoothly. A word of thanks must also go to the MCs of today in the morning and in the afternoon. Finally, Hong Kong welcomes you. As the forum heading says, come and do business in Hong Kong. Thank you very much.
Thank you, Mr. Sum. we are now approaching the end of today's forum. On behalf of the Law Society of Hong Kong, we would like to express our gratitude to the Professional Services Advancement Support Scheme of the Government of the Hong Kong Special Administrative Region for the funding support. We would also like to say a big thank you to all of you joining us today in person or virtually to make this event a huge success. We look forward to meeting you all again at the Law Society's event in the near future.
Goodbye.
Goodbye.